So a year ago, July, the board of directors said, well, this is a big enough issue for our membership that we need to address it. And they said, we're going to cover it. We're going to cover both the defense and indemnity on that. And that was a split house, and it was one vote that said, we're going to cover. And it came down to, out of the 20, I think we had 27 in attendance at the time. Anyway, the majority ruled by one vote. So clearly the split house. Went back into, kept it internally in our, one of the committees looking at the coverage underwriting committee and said, okay, what's going on with the public records? Are we having a lot of activity here? What's the nature of it? That kind of stuff. Came back up this July. And this July we had the same kind of discussion. And this July, by about 2/3 to 1/3, it was decided not to cover it. And the thinking was this, is that this is an administrative act of the counties or cities, in fact all municipalities. So it shouldn't be any different than complying with the speeding laws or complying with EPA rules over your closed landfills. And so there shouldn't be any coverage afforded to a county any different than speeding or fines to the landfills, that kind of stuff. That was the thinking. Still is a divided house, like say 2/3, 1/3. It may come back up again, we don't know. But the board of directors said, you know, we don't leave it there. We don't want to leave counties hanging. So they instructed us to do two things. One is to continue to provide the expertise back to the counties when there's questions about coverage, not coverage, redaction, all those kinds of things. We build up a fairly large level of expertise of people that we can bring to bear on the question. And then the second thing is to train the people in your organization, that is your public records officials, excuse me. Somebody or somebodies in the organization is the repository of those requests. And it may be in the clerk's office, it may be in the assessor's office, they may have their own, you may centralize it, I don't know how you set up your ordinance or your policy to deal with it. But someplace that record comes into. Whomever gets that record, we have set up a certification program for them. And beginning the first year, we will start certifying your public records officials. It's a 2-day course, and by the time they're all said and done, they will know the ins and outs of the law, the compliance requirements, and a checklist on how to go through when that request comes through. There's so much to it when we start talking about the metadata and all the other kind of aspects of complying with the act that we need to deal with, that we need to get that expertise to the person that actually gets that request in-house. So that's where we did the change, and that is to not cover specifically public records requests.
Let me ask a question here. If the county got sued, say, for releasing information, say somebody's unlisted phone number, and that caused them some damage, they thought.
That's a different story. That would be covered. Right. Right. It's just
the public records complaint or request itself.
Right. So, okay. Or if you have a triggering event and there's a public records request that comes in as a triggering event, there's a tortious action, somebody wants all of the information about that tortious act, and there's a follow-up in that side of it, then it would be wrapped into the original event. So you're covered in a couple of different ways, but just the standard run-of-the-mill public records request, no. Second thing is we provided an opt-out provision, which is new to the policy. It pertains more to the larger deductible counties. We have counties that have deductibles up to $500,000. So they do a lot of their own claim administration and their own litigation with in-house counsel. And what we've discovered is that there are times when let me back up. The way your interlocal agreement works, every claim that comes in belongs to the risk pool. We delegate back to the member counties the ability to adjust that claim on their own if they choose to, up to their deductible level or $50,000, whichever is less. So in your case, you're a $10,000 deductible county, so you can adjust claims, and Lorna does that all the time, up to $10,000. If there's one that you don't want to do or don't have the expertise to do or something like that, we just take it over and we adjust it for you. So it's something that we do as part of our work on your behalf. If you have a $500,000 county, however, and $50,000 is the cap at which you can adjust. Oftentimes they're into the case themselves. So they've got their own attorneys in-house working on these civil litigation issues. And at that point, we have to negotiate with the county and say, okay, we're going to take it over and provide the defense and all that kind of stuff, or we're going to allow you to, given that you're already this far into the case and you have this kind of expertise on staff. And some have done really good jobs and some haven't. And unfortunately, the ones that haven't have created some real problems in terms of our selling our risk off, which we'll get to in a second. So the discussion was, well, when the county or when the pool wants to settle a case out, and we look at it from primarily from a business decision, because we have 28 counties in this pool, we're all putting our money in, so we're looking at what's the best interest of the 28 counties, not necessarily what the best interest is of the individual county. So we make a business decision, we think we ought to settle it because there's this much risk, and in this state, with no caps on pain and suffering, the sky's the limit in terms of what the jury could award. The county, on the other hand, says, well, wait a minute, we want to litigate this, we think it's a very defensible case, and we disagree with you, pool. Well, there was never a way for us to reconcile that other than the pool always had the trump card, just like any insurance company would have the trump card. Well, so we provided this opt-out provision. And what it says is that the county wants to go on their own, they're able to do that. At the time that the legislative body, which only the legislative body can agree, but essentially the legislative body pulls that one case out away from the pool and takes it on themselves. And it's really a change to the interlocal agreement. That's why it's the legislative body that has to make that decision. At that point, we pay all the bills up to the time that the letter's signed, and the county takes off and goes on their own, and the pool no longer has responsibility for that particular case. And it's on a case-by-case basis. Doubt it's going to be used very much, but it's some of the larger counties, or largely deductible counties, you should say, have asked for that kind of flexibility so they can go ahead and litigate.
Just a wordsmithing. David mentioned that it may not be in the best interest of the county. I'd probably take a different take on that, is that I believe that most of these decisions where there have been problems in the past, it isn't so much that the decision that's being offered, the proposal that's being made, isn't viewed as being in the best interest of the county as well as in the best interest of the pool. It's that typically the representatives of the county are looking at it from a more biased position, and not as objectively. They're not considering the risks that are associated with the rewards to the greatest extent, and they're more interested in perceiving that reward or pursuing the reward, and are willing to accept the risk, even though, as David mentioned, that we have a few instances where those risks have developed fairly significantly in recent times, and as a result our direct impact upon the rate adjustments that have been forthcoming this year. So.
Okay, and the last part is we brought our document in line with RCW 4.96, which deals with indemnifying and defending employees that are working within the scope of their employment. Our policy identifies and defends that employer from the get-go. But it's the legislative authority that has to decide whether or not they're working within the scope of their authority or not. Oftentimes you won't have all the information to make that decision early on in the case. But what this does is that make sure that we come back and touch base with you all to make sure that this person is working within their scope, and so we can proceed. But it doesn't change fundamentally what we do, other than we make sure that on the record some places whether or not they were working within the scope of their